Good evening. My name is David Greenwald. We are here with Vanguard Court Watch Live, and we have three interns from the Vanguard Court Watch program, Danny Silva, Lauren Zarin, and Carly Gunn. Welcome, guys.
Thank you.
So last Tuesday, it actually only took a jury 90 minutes to acquit Lucio Paniagua of charges of lewd and lascivious acts with a child under the age of 14. He had allegedly inappropriately hugged and French kissed an 11-year-old girl at a baby shower. And what caught my attention about this case was here you have sex abuse allegations in a case involving a young girl and a very quick acquittal. To me, 90 minutes really means the jury saw that there was really no case here. So last week I interviewed defense attorney Monica Bruscia of the Yolo County Public Defender's Office, and she told me some interesting things. First of all, she said, I don't believe there was sufficient evidence in this case. I don't believe this case should ever have gone to trial, much less been charged by the people. There was no corroboration of the statements by a little girl. Sometimes children are put in those situations where you have to go to trial on it, but in this case it's a party and there are other children in the room. When the child is saying this happened to her and no one else sees it, there's no corroboration there. And it's not like a touch on the arm that no one would have seen. It was an adult male French kissing a little girl. Everyone would notice that. When there's no corroboration of that, it should never have been brought to trial. It's one of those cases where the district attorney's office needs to have better evaluation of cases that they file against. So I wasn't in the courtroom. These young ladies were. Maybe Danny, actually, who saw the opening statement? Was it Lauren?
I wrote the first one.
Okay.
About it.
So Carly, so can you kind of tell us what the facts as you understood them to be?
So Diana Hayes was the prosecutor on this case, and she did the opening statement. And so she kind of just described it as this night at a baby shower in Woodland, and there was a bunch of families and neighbors kind of all coming together for this baby shower. And as the night kind of continued and people were leaving, children were playing the popular game Fortnite. And so the victim at the time got up to use the restroom or something of that matter, and Mr. Paniagua kind of pulled her aside and said, hello, like, how are you? And then based on the statement, he apparently not only hugged her from the front, but also then hugged her from behind, turned her around, and then French kissed her and put his tongue in her mouth. So that's what she said. But then kind of one of the issues that Diana Hayes stated was that her statement had changed. And yes, the core fact of the statement didn't regarding the French kiss, but the location which it happened did, whereas Mr. Paniagua claimed that he just went inside to use the restroom and left. And so kind of what happened through the night was then the victim, am I allowed to say her name when it's over?
No.
Okay, so I still shouldn't. Okay, so she told the owner of the house, and then she then got the police involved, and at 3 a.m. this kind of situation is still ensuing and still happening. Whereas Miss Bruscia, the defense attorney, she claimed that it was more of a, issue about racism, and that the hug was more cultural based and kind of dealt with, I believe he's of Hispanic culture, and so it kind of dealt more with that. So those are kind of just the basic facts of the case and kind of what that night saw and how it came to trial with those facts.
And what did you guys hear in the case?
So I was there the second day, and I got to see the alleged victim testify, and she probably spent about 2 hours talking, and a lot of stuff that she said didn't match up with, I was there the second day, where the defendant's nephews and nieces testified, and a lot of what they said were not consistent. Like there were lots and lots of holes in the story.
And what did you hear?
I mostly heard, I heard all of the closing statements, and I had also heard, I believe it was the beginning of MDI, which is a multidisciplinary interview of Lily. Are we going to cut that out?
Edit that out.
We can. better if you don't. That's what
No, I got it.
Keep
Sorry
going.
about that.
It's okay, just continue.
So I had seen a multidisciplinary interview of the victim, alleged victim, and what had happened was there were a lot of technical issues there, but for the most part, like what you had mentioned with the opening statements, the closing statements had this notion of there was a cultural difference. And that's specifically what Brucia brought up, the fact that he liked hugging and kissing on the cheeks of his nephews and nieces, that he was a very family-oriented man, but he never had children of his own. And so there was a very big cultural difference in how he approached children. But it wasn't really the fact that, like, he didn't perform a lascivious act because he didn't intend for it to be a lascivious act, and it wasn't a lascivious act. It was a very friendly hug. It was a very friendly kiss, a kind of familial in a way, is what they argued. But a big thing also was the fact that the evidence that was brought in was very curious. There was apparently cologne on the victim's clothing, but that could have been from the fact that she was in a man's room when she was playing Fortnite. There was also this argument of DNA evidence, but the DNA on the clothes also happened to be, it couldn't conclude that there was male DNA, but it didn't exclude there was male DNA. So there was this question of, was DNA evidence really that important in this case?
Interesting. So, from what you guys saw, did the jury get the verdict right here?
Personally, I think yes. I think the fact that the jury came to a decision within 90 minutes speaks a lot to the case, and honestly, the lack of case that was there. I think that the prosecution really fell flat in its effort to have concrete evidence, and I think the fact that the victim's statement was very inconsistent kind of allowed for that to kind of fall through. And I think Brucia's argument that it was a cultural thing, I think personally that was to me it was a little bit of a stretch. I don't care. Most people, regardless of culture, don't stick their tongue in someone else's mouth. I don't know. I think the hugging, of course, could be a cultural thing, even a kiss on the cheek. But I think the French kiss, to me, was kind of far-fetched a little bit. But I think, I think they did get it right. I think that the victim was just too inconsistent the whole time. I mean, the location of the act had changed in every single statement. I hope they were, I hope they were right. I hope that the man actually isn't, I hope he's innocent. But yeah, I think the fact that they came to it in 90 minutes speaks to what they felt to be true.
Lauren?
An interesting thing I wanted to bring up, I wish I had seen the closing statements and the whole cultural argument, because the first day I went, the victim testified, but also her mother did, and her mother was explaining to us for a while about her child's history, and that she was autistic, and that the first 6 or 7 years of her life she refused to let anybody touch her. Like, she was which is a common trait of autism. She wouldn't let her family get near her and hug her or kiss her or do anything normal like that you would normally do to a child. And then also that she had been in special ed classes, and she just transitioned out 5th grade. She was in 6th grade now, but she had a really rough first year in a regular non-special ed class at her school, and she hated school. And she made some comment that I don't know how relevant it was about the not getting any recognition from her principal, and that her principal would recognize other people and give them awards, and she wanted one. And so some of those things pointed to the fact that she could have exaggerated or made up a story, or maybe it was true that he came in and hugged her, and she, just because of the way that she was, reacted to it in a very extreme way. And yeah, I don't know how that explains the kissing. I don't know if a kiss on the cheek, how she would have gotten from that to French kissing, but
yeah, specifically in closing statements, the defense had argued she could have exaggerated because she has a very restricted space, that she doesn't really like being touched all that much. But there was also this statement from the prosecution. The victim had used a particular term, "his tongue touched my tongue," which was something that the prosecution went back to over and over and over again. And in closing statements, she had Hayes had stated it had a ring of truth to it. Like, it was phrased in such a way where she didn't want to not believe it. And that's I can kind of see like that, why that could be the reason why she pursued this case in particular, because it's such a strange way of phrasing it, but it gets such a clear idea across. But at the same time, there's this idea of she could have been exaggerating, maybe she didn't completely comprehend it. One thing I do find very good about how they both analyzed this case was that the testimony of a child should not be like disregarded, is what they both had mentioned in closing statements. That even though the victim was a child, you could still kind of listen to her, but while her testimony kind of was a little everywhere, like, just the fact that she was a child did not mean that she should have her testimony disregarded.
Well, I think it's interesting that this kind of brought up and that they both kind of had that in their closing statements, and that you should value and take the statement of a child seriously, because I feel like with the argument brought up about her autism and the idea that she felt under-recognized kind of then goes to this idea of credibility. And I feel like when you bring up the concept of, her having autism and these things of not being recognized at school, that kind of lacks her credibility in this. But then they're also kind of with that counteracting the fact of like, no, you should listen to a child. But it's like, if you're kind of discrediting her, then which side are you actually taking when you say that?
Yeah. And so, like, I think specifically in the terms of, like, considering her autism, it's taken more into an individual view. It's not, oh, this is a child, so we should ignore them. Oh, this witness is autistic, so we should disregard, like, certain aspects. It's the idea that a person is of many different facets, and so they are formed as an individual through those different facets. And so that kind of colors a person's testimony, which is very important to understand that there are all these different aspects. For example, the defendant comes from a different culture, he has different practices, and those very much didn't match with the alleged victims' practices and just usual day-to-day routine and interactions.
And one of the factors, I think, is the lack of corroboration. That the point that Monica Bruscia made to me, at least, was, hey, if this actually happened in a room full of children, somebody would have seen it, and they didn't see it, or at least from what I gathered.
From closing statements, specifically what Bruscia had brought up was the fact that all the kids were up on the front of the house and all the adults were in the back of the house, and so like the inside of the house was pretty much empty, save for the kitchen where you can get food. So the children, specifically the victim and her two friends, had been in a room inside of the house near the kitchen. And we saw a picture of the room, and it was fairly small, and you can like easily see the door, and you can easily look out and see the kitchen. And so there's also this idea of like, where was the supervision there? Like even the children who had been in the room would have been able to see this interaction. And I believe that one of the friends of the alleged victim actually retracted her testimony or changed it.
I'm not actually sure about that. I know that two children that were present did testify, and that they said that they didn't see anything. Because one of the victim's statements was that the kiss had occurred in the bedroom on the couch where the other children were playing. So if that would have actually happened, then there's no way that would have been missed by the children, or that the other kids wouldn't have seen that. And even if it, per se did happen in the doorway, it's still kind of what you were saying, it still wouldn't have been missed. Like, there's still, it still would have been seen, and there were just too many people for that, I feel like, for that to happen without it going recognized. And I think one of the arguments that kind of was brought up was timing, and that he briefly went to the bathroom and or supposedly went to the bathroom.
Yeah, the thing is with the bathroom thing, from what the closing statements at least had stated, he had asked to go to the bathroom to like the owner of the house. He was like, "Can I use your bathroom?" And he was like, "Yeah, totally." Goes in the house, leaves the house, asks for the key so he can go to his own bathroom.
Yeah. I was gonna say I don't even know if he actually used the bathroom at that time. That
he said there
he was asking. Yeah, that's what I remember. Is they said like he didn't actually end up using the bathroom. He just went home instead.
Yeah.
And what was he doing there in the first place? Was he a friend of the family,
He
or
was invited over? Like
He was a neighbor.
Yeah, he was invited over. He brought over like 6 members of his own family. He had left like a little bit after he arrived because they asked him to bring a karaoke machine to the back.
Yeah, that's right.
Yeah, so they were like pretty friendly to him, and so there was. I'm not exactly sure how he ended up being held accountable for this.
Well, yeah, I don't think he was a stranger. Like, I don't think he was a stranger by any means. I think the woman that was, who the baby shower was for, I think she knew him and, had some idea of his family because they were close neighbors. I think it was probably in a typical cul-de-sac neighborhood or something.
They were, according to his niece and nephew's testimony, the defendant's niece and nephew's testimony, they lived 4 houses down.
Okay.
And only one of them though, one of the children, who was probably about 9, claimed that the husband of the lady who had the baby shower actually went to their house and knocked on their door and said, "Hey, we're having a baby shower today, come over."
Okay.
I'm not sure how true that is, but they knew, and they had already been there. They had gone to one party before. I don't know if they just got to know them or if they just recently moved, but they had only been to one party before at the same house.
So, kind of to summarize, get each of your thoughts on this. So what went wrong with this case?
I kind of heard this through grapevine because I also talked with the other interns about what evidence they bring up. I think the main one was from the alleged victim. She did not recognize the defendant in the room. And that's sort of the thing. If you would believe that if a child or any person were touched in such a way, they would be able to recognize this individual. And well, I actually kind of hand it to you because.
Yeah, I mean she was asked on 2 separate occasions within the span of 2 hours, and both times she said, "No, I don't see the man," in court, which I found weird.
So, I do think there's one thing that people should be kind of cautious of, and that is you have all sorts of problems with people being able to identify others, especially people that they don't know that well. You add a traumatic situation, and then you add the fact that she's an 11-year-old child, and so to me that's not hugely surprising, especially, this wasn't like a whodunit. This was a did it happen case. So it's not like they didn't know who the guy was. It was more like, did he do what she said? I don't know how much bearing that actually has. So it may have played a role with the jury, but in terms of, the actual, is he innocent, is he guilty, I'm not sure.
What I think, just kind of going off of that, what I think, I just think there are so many pieces to this puzzle, and just none of the pieces seem to be fitting. And I think that, kind of like what you were saying, say it did happen and there was this moment of trauma. I mean, I know that when I get really nervous sometimes, or something traumatic or weird happens, I almost like black out for a second. I'm like, wait, what happened? Or like it's like this blank in memory. So I think I kind of agree with Lauren in the fact that, like, I don't know how much weight that actually does have, and like I think it's obviously crucial if she didn't recognize the guy that she was supposedly accusing, but I think there's so many different things that can attribute to why that could have possibly happened. And I think, maybe one, if she did have some sort of disability and age, for sure, and definitely I think just being 11 years old and being in front of a court and knowing that, like, there is some sort of consequence happening with this. And
she's autistic, so her brain processing may be a little different anyway.
That's what made me assume, because facial recognition I know is a big thing, like the inability to recognize faces, or like it's a social disability. So that made me think that, especially if she was a child, and if it was a traumatic situation for her, that there's not like it's not certain that she would be able to point out the man, especially if right now he was in a suit sitting down. And I don't know what he was wearing, but he was probably not wearing a suit to the baby shower. And sometimes I think you can focus on other things besides the person's like facial features. I think that's easier sometimes for people to do.
Yeah, and I think definitely, like, say it did happen, it was very brief. It sounded like, and I know that for myself, at least in brief interactions, I don't always remember people's faces. I remember the action or what we talked about, but I don't always remember, exactly the contour of their face. And kind of like you said, if he's dressed very differently, that makes sense. And it's not like someone she knew. It was someone that was probably the first time she'd ever seen him.
So, kind of from the 10,000 foot level, I think, there are a couple of different thoughts here. So the first thing is, here you have a guy who ends up being in custody for about 8 months. He's acquitted in 90 minutes. And so the question is, was this a case that should have been tried at this point? And by the way, this guy gets beat up. Like he's assaulted because he's accused of this crime. So there's several different elements to this. Looking at this from not from the victim's standpoint, but from the criminal justice system standpoint, is this a case that proper discretion was used by the DA's office in your estimation?
Personally, I don't think so. I think the fact that it did take 90 minutes definitely says no. And I think, I understand from the DA's perspective, if it is a child and there is a molestation case going on, they have the responsibility to look into that. And I think that something like that is very important and it does demand attention. But I think the prelim could have been, ruled that out. And I think that if he is rightfully innocent, I don't think that he deserved to sit in custody for 8 months for something he truly didn't do. And and so I think it's kind of hard because you can't always tell in the beginning. I think that sometimes we wouldn't have known unless the case actually went to trial. And so I think it's almost sometimes a little impossible to say.
It would have been interesting if we had seen it in prelim to see if we felt like it was that much of a quote-unquote dud case, or if it seemed more promising. Sometimes, I'll sit in a prelim and I'll be like, okay, this case is never going to get a conviction on it. They better figure out a way to plead out right now. And sometimes you go, okay, the defendant has no chance in this case. They better plead to something because they're going to get convicted. And unless we've seen the prelim, it's hard to gauge that. So your thoughts on this from kind of the 10,000 foot level?
Yeah, well, what we were saying like 10 minutes ago about the fact that she didn't recognize the guy in the courtroom, and the idea that that it was not like this did happen and this was the guy, and now let's see what's going on. It was more like, did these events even occur? Which seems to me more like a prelim level, that like they weren't the only evidence that they didn't have any physical like substantial physical evidence. They had this girl's testimony, and they had basically, from what I gathered from other people's articles and from being there, all the other witnesses' testimonies had different certain things that were consistent throughout the rest of them and that were inconsistent with the victim's testimony. And they were really, really resting the case on the validity of the victim's testimony because there wasn't any physical evidence. So based on that, I'm not sure how it got through prelim. Like what I guess my assumption would be the race dynamic, that it was a young white girl and a Hispanic man, and it was what he was accused of, is why it got pushed forward. But I don't know if it should have gone past prelim.
Danny, your thoughts?
I'm not sure what evidence was brought before the prelim. I think that, well, if it is a child molestation case, I can kind of see where the court is like, okay, there can be an occasion where there's not enough evidence right off the bat. There's also the occasion of we don't know who the public defender was. Was Bruscio defending him from the beginning?
Oh, I don't
Yes.
know.
Yeah, she
Okay.
was.
I believe so, yeah.
Yeah, so if she defended him from the beginning too, like, potentially there was the possibility of, like, she also believed that this wasn't going to go through, and then she was like, oh, all right, I guess we're going to go to trial with that.
Yeah.
But specifically speaking on the DNA evidence, I had also seen the DNA evidence being presented with the multidisciplinary interview. Yeah, it's such a fun word, MDI. I had also seen someone testify on that from the Sacramento Testing Center, and they had said, like, you can't exclude male DNA from, like, they had taken into evidence Lily's clothes from that. They had taken the victim and the defendant's clothes from that day, and they had taken a DNA sample from the areas in which the alleged victim had claimed that she had been touched. So, like, areas on the pants and whatnot, or shorts specifically. And she had tested that, and the tester had said there was no conclusion that this was specifically the defendant's DNA. There was no conclusion that this didn't come from, like, the couch that they were sitting on as they were playing Fortnite. So the DNA evidence was, like, off. There was also the testimony that was taken the night of, like, the alleged victim had been interviewed at 3 a.m. after being woken up and interviewed by this officer in the middle of the night, or technically early morning, but that kind of also kind of colors the testimonies that were given as evidence. So I do kind of think that it is a shame that he had to go into custody for 8 months. I really do think preliminary-wise this could have been dispelled. It's just a matter of, like, what evidence was brought forth in the preliminary, and that can very much color whether or not it should have gone to trial.
Well, and kind of, like, just based on what we're talking about here, I feel like that's exactly where the prosecution fell flat, was the lack of DNA evidence, and as well as her statements that were not only inconsistent, but she wasn't able to, identify him in the room. And I think, because in the opening statement, Hayes said, I'm letting you know now that when we tested for DNA, not only on her clothes, but also in her mouth, there was no DNA of his. And so I think she knew that she was going to have this battle, and ultimately she lost. But I think that was something that she kind of knew that she was going to have a problem with, and it did turn out to be a problem.
So I think if you evaluate the case this way, you have inconsistent statements by the victim, you have inconsistent to anti-corroboration by other witnesses. You don't have any DNA evidence to back you up. You have the victim basically saying, I don't see the guy in the courtroom. Nothing's going right for you as a prosecutor at this point. There's nothing in this case to say, oh, okay, there's something took place here. And the other point I think I want to make, and I'll be careful because, as a father, I certainly would be very unhappy if some guy tried to French kiss my 11-year-old daughter. But, there's a difference between that and some maybe more serious molestation stuff that I think, you gotta weigh it all out in terms of, okay, this is our case. It's not particularly strong. The crime level is, probably, if it's on a scale of 1 to 5, where 5 is like, off the charts horrific, and 1 is, petty larceny, it's probably in the 1 to 2 range rather than the 4 to 5 range. So I think, you weigh it all out, and there's got to be some discretion here that I'm just not going to win this thing because I don't have anything to back up the statement other than a little girl who's giving very confused testimony. And if you think about it, and I'll come back to the original point that I made here, normally I argue that it is not, the burden of proof is not on the prosecution. In reality, the burden of proof is on the defendant. The jury automatically assumes that if that defendant's in the courtroom, they did something. Mm-hmm. So you have to overcome that. Then you take an 11-year-old little girl, and you probably double that calculation. So they really have to be proven that he didn't do anything. And for them to come out of there in 90 minutes and acquit under those set of facts is pretty extraordinary. They are looking at this case, and I mentioned this earlier to you guys when we were talking about this, but think about it. You give your closing statements and you get called back in. If you're the defense attorney and it's 90 minutes, you're like thinking, oh man, this is not good. It just doesn't happen that way. Usually when it's an acquittal, it takes a lot longer. They have to tease through it. They have to decide that there isn't proof beyond a reasonable doubt. This didn't happen. They basically assessed the situation, came to the conclusion that the only piece of evidence that really linked him to a crime was the words of the little girl, and those words were inconsistent at best. And then they acquitted. Any final thoughts?
Yeah, I think what was kind of interesting was kind of you're talking about how do we weigh this, and is it something that really can be weighed? And I think one thing that was also very important about this case was that Paniagua was not a relative, and he was not someone that was regularly in this victim's life. I think if it was someone that she was regularly surrounded with, maybe it would have demanded a different type of attention. But I think the fact that this was a guy, they didn't know each other, there was no past history, and kind of just this one-time thing of something that wasn't as horrendous as the most horrendous things, and so I think that's definitely something to be noted.
Any other thoughts? All right. Thank you, everybody, for viewing in. This has been Vanguard Court Watch Live, and you can log on to the Davis Vanguard every day and get Court Watch stories on the Davis Vanguard, and you can also go to vanguardcourtwatch.com and directly log on and get the latest from the Yolo County courts. Thank you.